Hi, in the last class we talked about data protection law and its conflict with freedom of speech. Basically, data protection law gives the right to gives data subjects the right to control data about themselves, and it gives them ownership like control on the data about themselves. For instance, I can control data that K.S. Park is a bad professor, and you know how I will exercise that power. I'll exercise that in my favor. So that gives data subjects some sort of censorship power over the data about themselves. Now, that potentiality, that possibility did not really become a reality until Google versus Spain decision, which is often called the right to be forgotten decision. And it has a subtitle, right to be forgotten. So let's look at the first slide, right to be forgotten. What is it? Right to be forgotten described claims made by people who want to prohibit others from remembering their undesirable past. For instance, prostitutes who want to lead a new life. They wanted others to not to find out about her past, so she will request the media companies or the local media not to release her names in their her name in their stories. Also, petty criminals who are trying to lead a new life. Also, bankrupt businessmen who want a second chance. They all want to hide their past, and they've claimed the right to be forgotten. And some governments have listened to them and made laws that expunge prior criminal records or prior bad credits, so that they can lead their lives without being worried about their reputation. But that's where the right to be forgotten has, and also there was a court case where a former prostitute wanted to lead a new life, and a local newspaper, local media wanted to do a story on her and about her past as a prostitute, and she filed a lawsuit to stop the media from reporting that, and she actually won. So that court case also represented one of the right to be forgotten theory. But that's where right to be forgotten stopped, right? Either expunging official records or expunging from private media space the stories about their past, when their past is something very inflammatory, like prostitution. But it didn't go to the level of prohibiting private conversations about these people. I mean, should other people be banned from speaking about the past of former prostitutes or petty criminals or bankrupt businessmen? when they're passed, are not really confidentially held or privately held information. So for instance, somebody going bankruptcy, somebody filing for bankruptcy, that's usually public information. And somebody being charged and going to prison, that happens through a public trial, so that's public information. Maybe so for all this public information, should people be banned from sharing that information just because the subject of the information won't be forgotten about their undesirable past? And we already know a strong argument against that when we talked about the argument that we discussed in relation to truth defamation. If people are prohibited from speaking uncomfortable truth about other people, then they cannot make decisions, they cannot make correct decisions to protect themselves. People protect themselves. People try to be safe in selecting their business partners or schools to go to, hospitals to go to. If they don't know truth about how these hospitals or schools acted badly toward their students or their patients, people cannot protect themselves. So that argument against truth defamation has been effective in confining the right to be forgotten to confining the coverage of right to be forgotten to expungement of only official records or suppression of information from private records when the information is something inflammatory as prostitution. And if you think about it, prostitution takes place in a private space under implied promise between the customers and sex workers that the fact of prostitution will not be made public. So you can make a pretty good argument that prostitution, one's past about prostitution belongs to his or her privacy. So that's where right to be forgotten jurisprudence has remained at. Expungement of official records, or concerning very private activities like prostitution. But Google, next slide, Google versus Spain decision came along. Here, a Spanish lawyer wanted to suppress a link to a web page about a link to a web page containing the news about the auction of his house 12 years ago. He was forced to sell his house under court-ordered auction to pay back his social security debts, basically tax liability, and he filed a lawsuit to suppress a link to the public announcement about his house auction. In the search results, where the search was done using his name as the keyword. Now his argument was that he was going through a difficult time financially 12 years ago, but now he's a successful businessman. But when people Google his name, one of the prominent search results is about his house auction, and he thinks that that information is irrelevant to his current financial condition, so it may mislead people about how he is doing now or how he is generally. So it's something that can be his house auction 12 years ago is a very forgettable past. It doesn't really reflect his true financial condition. So there's no reason that Google search results should include that. That was his argument. And lo and behold, the European Court of Justice accepted that argument and ordered Google to suppress that link or take that URL out of the list of search results. So we call that delisting, because you take something out of the list. So the court ordered Google to delist a link to the information, information about his house auction 12 years ago that he wanted to be forgotten about. Now, I'm going to tell you what this order is not. The court did not order deletion of the information about his house auction. It only ordered the delisting. So the order applied only to Google, not to the host, not to the web host of the information about the auction. Also, the court did not order delisting of that link from all search results, but only from the results of a search when the search is done using his name as the search word. Finally, the court said it will not order delisting every time someone wants to be forgotten about certain information, but only when that information is, quote, no longer relevant, unquote. What does it mean, no longer relevant? When you learn English, usually when you learn the term relevant, you always learn in the form of X is relevant to A, right? Relevant to something. It cannot be relevant in the vacuum. It has to be relevant to something. But here, the court managed to say that it is, the information is no longer relevant and therefore is forgettable. Next slide. Now, this new right to be forgotten, and the court, the Google Spain court called this decision right to be forgotten, and this new right to be forgotten is different from classical right to be forgotten because it concerns, it concerns. It doesn't concern just public official records, but it concerns communications among the private parties. So the public announcement about the auction was on a local newspaper, which is a private entity. A person trying to access that information are, normal internet users, and the company facilitating that access. Google is also a private company, so this right to be forgotten decision was different from the previous right to be forgotten decision in that it applied to non-official records made available by private, non-official companies. And also it concerned public information. Remember, I said I can make probably we can make a pretty good argument that prostitution is a private activity, so right to be forgotten on reborn prostitute can be justified under classical privacy concept, but here the public announcement about the house auction was on a newspaper. Actually, that web page containing the information about the house auction is actually a page out of a local newspaper. And public announcement of judicial sale, public announcement of court-ordered sale of assets is, it's there for the purpose of maximizing the value or the price that creditors and debtors can get from the house, right? The public announcement of auction is spread as widely as possible so that as many bidders as possible can come to the auction so that there is a sufficient competition to build upward pressure for the price of the house. The more the bidders, the better price you can get on the house that's being sold. That's why the public announcements there, they're on the local newspaper. So, this is not like prostitution. This house auction is maximally, right? Maximally publicized activity, unlike prostitution. So this new right to be forgotten is different from old right to be forgotten in that it applies to non-official records and it applies to non-private information. Not just non-private information, maximally publicly available information. How did this happen? Well, because it happened when the court based the right to be forgotten theory on data protection law. And remember that data protection law gives almost censorship power to the data subjects. So using data protection law, the court strengthened the censorship power or the strengthened control of data subject on the data about themselves, and the court applied that to the court strengthened that control so much so that now the data subject can expunge non-official records. Right, expunge from non-official records the data that they find undesirable, and also strength so much that they now have power to expunge from non-official records information that's not private, information that is public, information that is on a local newspaper. Actually, speaking of publicly available information, Google is not making available the house auction information itself. What Google is doing is merely giving the IP location information, URL, right? www dot blah 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 blah. That IP address of a web page where the information is at. And that URL is also public information. Everybody knows that if you open a web page and if you don't block search engines, web crawlers, the software developed by the search company, search engines, the web crawlers will visit, will occasionally visit your page and build a search index so that if anybody is looking for a certain search word, if that search word is in your web page, then the search engine will take the URL of your page and give to whoever entered the search query. So this new right to be forgotten is criticized, and the following arguments are particularly interesting. So the court said, okay, this information on the house auction is not defamatory, it's not privacy infringing because it is publicly available. But this information, search for the information on house auction should be suppressed because the information on house auction is no longer relevant. But as I said earlier, no longer relevant from whose perspective? I mean, from the perspective of the lawyer who want to create the image of a businessman who has never failed, yes, this information is not only unnecessary, this information on the house auction is not only unnecessary, but it is conflicting with the image that he's trying to build. And many people may not find the fact of auction of one nameless lawyer 12 years ago not important, but there can be people, there can be small minority who find that information very useful. For instance, a researcher in Spanish judicial profession may take the fact of house auction as a good anecdotal evidence that not all Spanish lawyers make a lot of money, and also there may be people, there may be potential business partners who are very purist about whom they work with. I can totally see a businessman who will never work with another person who has gone through bankruptcy. Or I can easily think of many people who will want to know the full truth about their business partner's financial past before venturing upon something together. Yes, it may be unimportant for the general public, but what kind of information is important for the whole public? The information, especially information in the archive, is useful only for a small minority of people. And in a pluralistic society, a small minority, the interest of a small minority must be respected. Information cannot be suppressed just because the data subject doesn't like the information, or just because some judges or commissioners cannot think of creative ways of finding that or drawing value from that information, or because the majority do not happen to pay attention to that information at the moment. And the majority's interest can also change. What if this lawyer later runs for an office? Voters will want to have all the information about the financial past of the candidates. If the candidate has the record of not having paid Social Security tax, that is a relevant event for the voters. So this rule that some information can be suppressed, the circulation of some information can be suppressed just because the majority public, don't find it important, or the commissioners or the officers representing the majority public cannot think of ways in which the information can be useful, is conflicting with the pluralistic ideal of the society, and also the fact that the value of information can change over time and depending on the position of the data subject. For instance, when data subject enters into big business deals or runs for an election. So that's one critique. The second critique is, it's not, this is a critique against a counter argument in favor of right to be forgotten. Basically, some proponents of right to be forgotten argue that the original information, the information of House auction, is not deleted from the online archive of the local newspaper. So people can access it, people can come across that information while they are surfing the net. So it doesn't, yes, there's some cost on people's freedom of information, but not much cost. But is that true? The internet, there's so much information, and you've heard the saying, too much information is like no information, right? Because if you have too much information, it's impossible to find the information that is useful to you. So it's like having no information at all. And the internet is like that. So unsearchable information, information that will not be caught by search, is like non-existent on the internet. Also, if people begin manipulating the search results of a search done using their names as keywords, then guess what will happen? The internet, one of the gifts that the internet gave to the humanity is that powerless individuals will have the same power of information as big companies and governments. But how? Through search, through the search function. If there is no search function, the only way to find information will be, visit one web page after another, and billions of web pages are out there. Only the rich people will have time to go through, will be able to hire people to go through the web pages to find the information that they need. If the search doesn't operate in the efficient manner that it has, then the only way to look for the information you want is go through one web page after another. So the poor people will not have the same power of information as the rich people who can hire people to go through the web page by page. Because, why are we saying this is going to happen? Because people will ask Google to take down or suppress negative search results about them. So the only way to get to see the full truth about the person will be go through the web page by page to get all the information. You don't need to go through the whole internet, but you will go through, for instance, in this case, if I'm a rich person, who wants to find out about the Spanish, this particular Spanish lawyer, I'll hire someone to go through the local newspapers in the area where he lived. But if I'm a poor person and want to find out about this lawyer, I'll have no money to hire a person to do that, because the search results will not bring up that negative information about the Spanish lawyer. So that was the second critic. Now the third critic is this: why do we want right to be forgotten? Right? Why do we want the right to be forgotten? It's because we don't want people to be unfairly discriminated for their past wrongs. People can make mistakes, but people should not live in the prisons built by the past mistakes. That's the real reason that we want right to be forgotten. But if you want to fight discrimination, what's the true way of fighting discrimination? Let's say you want to, fight discrimination against homosexuals. If you suppressed information about your sexual orientation, is that the real way of fighting discrimination? I mean, you blind people from facing the fact that some of us are homosexuals. Is that the true way of fighting discrimination? Isn't the true fight against discrimination where you challenge the society to see the fact that some of us are different than others, and challenge the society to treat us the same? Yes, if you blind the society from our, if you blind the society from our differences, yes, the society will treat us the same, will not be able to discriminate because the society has no information. But the society will still live in the ignorant, discriminatory tendency if we just don't challenge the society to face the differences and accept them. So if you really don't want reborn prostitute, if you don't want former prostitutes not to be discriminated against, if you don't want former bankrupt businessmen not to be unfairly, unreasonably discriminated, the real way to make sure is that the real victory in that fight will be to give the information to the society that this is a reborn prostitute, this is a formerly bankrupt businessman, but they can still do the job. They are still decent human beings, and they should be accepted and treated just like anybody else. That will be the true fight for discrimination, fight against discrimination. And also, is it really a proportionate? Yes, fighting discrimination is important, but is that the true way? Is it really proportionate way of fighting discrimination? Making us blind to other people's past? Do we really have to take away our chances to protect ourselves by making, best choices in selecting our business partners or selecting our schools and hospitals? By hiding truth about others, we are making ourselves vulnerable in making selections. Is that the cost? Is that a reasonable cost to pay to prevent discrimination prevent discrimination, for the reasons that we think we think are unimportant. So that's the third critique. Next slide. However, the right to be forgotten is spreading to other countries. In Italy, Google Spain was only about suppressing search results of certain information, but in the case of Manny in Italy, a businessman made a request to expunge a corporate register of to expunge some negative information about his business off the corporate, the official corporate register, and the case is still in court. But in Japan, there was a child sex offender who filed a lawsuit against the search engine to delist the information about his past sex offense against children. The higher court, the intermediary court in Japan, the intermediate court of Tokyo, ruled that right to be forgotten does not apply here. So yes, it's spreading, but there's also pushback. Now, this controversy about right to be forgotten, about people being prevented from accessing the information that's not defamatory, that's not privacy infringing, that is lawful in every way. This problem of preventing people's access to completely illegitimate information that problem exists not just in right to be forgotten, but actually it is derived from data protection law, because data protection law protects all information about the data subject, whether it is even if it is completely lawful information. The data subject has ownership like a control over whether that data can be shared among the third parties. And the next slide, I think I have a solution. I think I have a solution to this twin problem of interfering with the people's legitimate access to lawful information, both in the right to be forgotten and the general data protection law. So, the controversy in right to be forgotten originates from data protection law, because right to be forgotten is based on data protection law concept, data protection concept that the data subjects have control over data about themselves. So what's the solution? Well, think about why we came up with the concept of ownership-like control over data about ourselves. Well, because of the concept, because the risk that when powerless individuals turn over data about themselves to the companies and governments, they don't have sophistication, they don't have resources to negotiate over with whom the data will be shared with, for what purpose the data will be used. And will not have power and will not have resources to enforce the conditions even when the conditions are violated. So data protection law or the concept of data ownership came in to kind of level the playing field, equalize the bargaining power between the powerless individuals and companies and governments by recognizing data subjects' ownership of data about themselves. It puts the pressure on the companies and governments to pay more respect to the wishes of the data subjects. It's not like breaking a promise when so if the data is if someone is considered to be the owner of the data, then even if the data is turned over to the companies and governments, if they use for some new purpose that the data subject didn't hear about, or share the data with some people that the data subject didn't hear about, it's not going to be just a breaking of a promise. It will be like a theft because the data subject owns the data, and the companies and governments who receive the data will use it against the owner's will and give to somebody that the owner has never consented to. So that was the idea about data protection. By making data owned by the data subject, now the companies and governments have a burden of proving that they have somehow obtained the consent to use the data in the way they want and share the data with the people they want to share with. If there is no ownership link between the data and the data subject, then if there was no condition about with whom the data can be shared, for what purpose it can be used, if there was no condition, then the companies and governments will have freedom of using it, right? But if the data is considered to be owned by the data subject, even if there is no condition negotiated, the companies and governments will have to come back to the data subject to ask whether they can use the data or share the data in the way they want. Just like your friend who borrowed the car for the weekend from you. Even if there was no specific conversation about not sharing the car with any other person, your friend will come to you because you are the owner and ask whether the car can be shared with yet another friend. So that's how we came up with the concept of ownership like a control over data. But think about publicly available information. There is no opportunity for attaching conditions because companies and governments already have access to that information about you. There is no data transaction. There is no transaction that needs to be equalized. There is no transaction where the parties' bargaining power have to be equalized. Because there is no give and take here. There is no give of information in exchange for receiving service. Right? To get treatment at public hospital, you give your health information in exchange for medical service. But publicly available information like that, Case Park is a professor, it's already out there. The companies and governments already have that information. I cannot later come in and say, oh, by the way, you can use that information only to say good things about me, but you cannot use it to say bad things about me. I cannot do that. So there is no condition that I can attach to publicly available information. So you don't need the concept of data ownership to prevent the companies and governments from using the publicly available information in the ways that I didn't think about, because the access is already there. Now, some of us may think that, hey, even the fact that K. Spark is a professor, that data is currently publicly available, but originally it was private information, and it's K.S. Park who made that information publicly available. So that data came from him, K.S. So he should continue to have control if the data is used in ways that he didn't predict, or used in the ways that he never consented to. But think about that. Does all information about a person come from that person? That I am a professor, that fact, where does it originate from? Does it originate from me? No, it originates from interaction. If I just give a lecture in an empty room, I'll not be called a professor. Okay. I may be called a mime actor, but I will not be called a professor. I'll be called a professor because there are people listening to me and trying to learn from me. It is from that interaction that the data that K. Spark is a professor originates from. I didn't originally own that data that I'm a professor. It came from interaction with students, the people who are the students to me. Only because there are students that I can become a professor. No one can actually own the data about him or herself. So my solution is that data protection law should not apply to publicly available information. So right to be forgotten also should not apply to publicly available information. And this solution, the next slide, this solution is already in some other important documents about data protection principles. 1980 OECD guideline on privacy makes an exception to data with no risk of infringing privacy. What are the data that has no risk of infringing privacy? Well, publicly available data. 2000 EU-US Safe Harbor Agreement also excludes publicly available data from its application, from the scope of its application. 2004 APEC Privacy Framework also makes exception to publicly available data. Canada, Australia, Belgium have data protection laws that make exception to publicly available data. Also, 1995 EU Data Protection Directive has journalistic purpose exception. The next slide, journalistic purpose exception. There, the information being disseminated for journalistic purposes are not covered by data protection law. So, in the Google Spain decision, if the court accepted Google's search function as a journalism, then the decision would have been different. And actually, I mean, if you think about it, what does Google do? When you put in a search query, Google's web crawlers search the web and report back with the URLs of the pages, web pages that contain the search terms. So they are also reporters. They report on the location, IP location of information. So that can be called journalism, but the court didn't think that way. But the same court, the same European Court of Justice decided this case, Satakunan, Markinaporsi, and Satamedia. In that case, a company provided text information about a person through SMS texting. So if you want to know about, if you want to know whether this particular person has paid his or her tax properly in the past, you could just send a text message to this company, and the company will send back tax information about the person that you wanted to you are curious about. There, the court found SMS texting journalistic activities and put the whole thing out of data protection law. So, I mean, this journalistic purpose exception is in some ways similar to exception for publicly available information, because journalism makes the information publicly available. Yes, there is a difference, because journalism takes information that's not publicly available and makes that publicly available. So it is different from exception for publicly available information, but there is the connection. And also, you know, surveillance is kind of watching something secretly, so that the subject of surveillance doesn't know that he or she is being watched. Of course, I mean, that's not the only definition of surveillance, but classical surveillance, the most poisonous model of surveillance will be watching without being watched. But journalism makes the information available to all the public, including the person being watched, right? So in the Satamedia case, you know, if you want to find out about what tax information the company has on you, you could send a text message and get the information so that you know what other people will get on you if they make the same request. So that's the solution I proposed. And I mean, let's go back to this issue of where personal data comes from. Does personal data actually come from that person? No. It comes from the interaction. For instance, if I have pastrami for lunch with you, that statement, the data that K.S. Park had pastrami for lunch with this person X, who owns that data? Do I? Or does my friend own the data? Or that data is made possible because my friend is there eating pastrami with me, and also made possible by me having pastrami. The data cannot be owned by any one person. The same thing. How about a statement? How about this information that Case Park had passed around for lunch with a friend, some friend, where persons A, B, C, D, E, blah, 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 X, Y, Z. So 24 other people were having lunch, right? The statement that I was having lunch with a friend at a restaurant where 24 other people were also having lunch, that data, who owns that data? I cannot own it because that data also concerns 24 other people. So trying to give ownership control, ownership is rivalrous. Meaning, if I own it, another person cannot own it, right? Ownership is exclusive. But if you try to give ownership control over to one person, then the other person loses control. So the whole idea of giving ownership control over data, data about yourselves, is conceptually a difficult project. So data protection law, I believe in need for strong data protection law, because the health information, the academic records, there are a lot of confidential information that needs to be protected, and when people give away that information to big companies and governments, yes, they need to be protected. They need to be protected by the concept of ownership. The concept of ownership that that makes the companies and governments respect your wishes as to how the data should be used. With whom the data should be shared. So there are times that the concept of data ownership is a very effective tool to protect our privacy. But as to publicly available information, that's where the metaphor should end. You cannot own publicly available information about you, and there is a reason for that. Data doesn't come from you. Data is created socially. Thank you.